New York City recently enacted changes to the Earned Safe and Sick Time Act that will impact how all private employers provide leave to employees. These amendments expand employee rights and will go into effect February 22, 2026. First, under the amended Earned Sick and Safe Time Act, employers must now provide 32 hours of unpaid safe and sick leave to all employees, including new hires and temporary workers. This is a new requirement. Previously, the law required paid leave of 40 hours or 56 hours a year, depending on the size of the business. Now, in addition to that paid leave, employers will need to front-load this unpaid time off at the start of employment and again at the beginning of each calendar year. Any unused unpaid leave does not carry over. The law also expands the reasons employees can use their safe and sick time. In the past, leave could be used for events such as personal or family illness and certain safety-related situations such as domestic violence. With these changes, employees can now also use leave to care for a minor child or another care recipient, attend legal proceedings related to subsistence or housing benefits, respond to public disasters, and address workplace violence that affect themselves or their families. Another key change under the new amendments is that most obligations under the Temporary Scheduling Change Act have been removed or scaled back. Previously, employers were required to approve up to 2 temporary schedule changes annually for certain personal events. For example, an employee who normally works from 9 a.m. to 5 p.m. might ask to leave at 3 p.m. for a child's doctor's appointment and make up the time later. These personal events are now covered under the Earned Safe and Sick Time Act's expanded leave provisions. While employees may still request temporary schedule changes, employers are no longer required to approve them. Employers should note that the Temporary Scheduling Change Act's anti-retaliation protections remain in effect. The amendments also codify the requirement that employers provide 20 hours of paid prenatal leave per year, separate from other sick or safe time. This requirement brings New York City law into alignment with existing New York State law. Prenatal leave covers pregnancy-related healthcare services, such as exams, monitoring, fertility treatments, and care at the end of the pregnancy, and it is available only to the pregnant employee. To comply with city law, employers must also update their Notice of Employee Rights to include details about prenatal leave. They are also required to show prenatal leave usage and remaining balances on pay statements or other written documentation and maintain these records for at least 3 years. Employers should work with counsel to review their policies and practices before February 22, 2026 to ensure compliance with the law. The Aiken team is available to discuss these issues.